Some of the things I'll be talking about may appear to be a little bit legalistic. However, it's a little bit difficult sometimes to talk about these things in a legal framework without some legalese creeping into the conversation. But I'll attempt to do my best. The first question that Katie's asked me to address is, what is regarded as extreme or radical activism in the eyes of the law, as what we term protest? Throughout Australia, there's no legal distinction between traditional or orthodox activism or extreme and radical activism, or as we know, protest. The distinction largely comes from the social perception and in turn the level of social acceptance of the actions associated with each form of activism or protest. All types of activism intended to progress or affect social or political change, sometimes through more extreme activism, might end up with greater penalties. This is likely to occur where the activism or the protest has caused detriment or injury to a person or property. The more serious the damage or injury, the higher the penalty is likely to be. People probably remember the protests in relation to climate change, where people actually superglued themselves to the road outside the post office in Brisbane City. So the damage there was probably hard to equate, because what it did was it disrupted the flow of traffic and prevented people from getting to work and upset people. However, it was a form, perhaps, of extreme protest that we would be familiar with. The next question is, what is regarded as legally acceptable activism in the eyes of the law? In Australia, our High Court has held that we have a constitutional freedom of political communication, even though the Constitution doesn't expressly say so. The freedom is more restrictive than the United States First Amendment freedom of speech. While Australia is a party to the International Covenant on Civil and Political Rights, which contains positive rights to freedom of opinion, expression, assembly and association, these rights have not been enshrined in federal law. So we don't, like the United States, have a federal Bill of Rights, or like Canada, a charter. However, some states and territories, including Queensland, have passed legislation to protect these rights in their jurisdictions. The Human Rights Act 2019, Queensland, which I was proud to be involved in, protects the freedom of expression. It describes it as two distinct rights: the rights of individual to hold opinions without interference, the rights of every person to seek, receive, and impart information and ideas, regardless of the means of communication. The Act protects the rights of peaceful assembly and freedom of association. It is also, Section 23 provides that every person in Queensland has the right and is to have the opportunity without discrimination to participate in the conduct of public affairs directly or freely or through freely chosen representatives. I will now deal with the last question, which is, do international students who aren't Australian citizens have the same rights as Australian citizens to protest? Laws apply equally, irrespective of whether an individual is an Australian citizen, permanent resident, or a temporary visa holder, like international students. This means that international students are afforded the same legal protections and are subject to the same legal consequences as Australian citizens and permanent residents. However, international students should be aware that the consequences which may follow from engaging in protests may affect their right to stay in Australia. For example, under the Migration Act of 1948, a Commonwealth piece of legislation, the Minister for immigration may cancel a visa if the visa holder is unable to satisfy the character test. There is a list of reasons why someone may not pass the character test. These reasons do not specifically include protest or activism, but if the activism involves, for example, engaging in criminal activity or associating with criminal associations or with a group engaged in criminal conduct, then this might present a reason to fail the character test under the Migration Act. If a person is removed from Australia on character grounds, they may have difficulty in satisfying the character test when applying for another visa to re-enter Australia. Also, international students should be mindful of actions that their universities may take in respect of protests. If engaging in a protest leads to charges or expulsion from their university enrolment, an international student will be in breach of the visa conditions 8202 and their visa may be cancelled. Some students may also be subject to visa condition 8303, which provides that the student must not become involved in activities disruptive to or violence threatening harm to the Australian community or a group within the Australian community. For example, engaging in or promoting extremist views and interrupting the operation of the Australian community. In most cases, engaging in protests may be a breach of this condition and the student's visa may be cancelled. I'd like to wish everyone all the best, and I hope the information that I've provided with you on this small video recording is helpful.
I'm Nick Dore, Managing Partner of Fisher Dore Lawyers. I'm an accredited specialist in criminal law. What should I do if I get arrested for protesting? The first thing is probably try not to get yourself arrested. But if you do, remember this. It's lawful for a police officer without a warrant to arrest an adult whom the police reasonably suspects has committed or is committing an offence. At the time of arrest, the police must tell you that you're under arrest and the nature of the offence you are suspected of having committed. Now, if you do unfortunately get arrested, once you are arrested, you must go with the police. You don't have a say in relation to that. Police may exercise reasonable force to prevent a person from evading arrest. If you do resist arrest, you may be further charged with further offences of obstructing a police officer or assaulting a police officer. Those terms are interchangeable, unfortunately. You then have the right to be taken to court for a bail application as soon as reasonably possible. Once you're arrested, you usually go straight to court, and the police will first take you to the police station or the watch house prior to going to court. The police officer must decide whether to grant you bail or issue you a notice to appear. If the police wish to question you about an indictable offence, that's really a serious offence that would proceed potentially to higher courts, you have the right to contact a friend, relative or lawyer, and the police have to delay questioning for a reasonable period of time. Now, that can be 2-3 hours to allow this to occur. Now, before you question, the police must provide a caution. So it's the stuff you see in the movies, you have the right to remain silent, etc., etc. But you do have the right to remain silent if questioned by the police. That is true. We still have that. There is an exception which requires you to provide your name and address to the police. So you have to give them your name and address. Refusing to provide a name and address is also an offence. So you can see how people get loaded up with several offences from these protests. The police may search you and your belongings after you've been arrested. They may seize anything found during the search the police officer reasonably suspects, may provide evidence of the commission of an offence. So leave your knives and illegal objects at home if you're going to go protesting, please. Police cannot detain you for more than 8 hours unless they get permissions from a magistrate or a justice of the peace. Police cannot question you about the offence for more than 4 hours of that 8-hour period. Police must discontinue arrest at the earliest reasonable opportunity if the person is no longer suspected of committing the offence for which they were arrested. Now, next question. If I'm arrested, will this be recorded on my criminal record? What effect would that have if I a social worker, a human service practitioner? We get asked this question a lot. The majority of our life is trying to stop people having convictions being recorded against them for minor offences. A criminal record is the formal record of offences that you've been convicted of, either because you pleaded guilty or have been found guilty. If you are arrested and later released without charge, this will not show on your criminal record. If you're arrested and charged, those charges are later dropped, dismissed, or you are found not guilty, that will also not show up on your criminal record. Employers must ask job applicants for criminal record details where there is a clear legal requirement that an employee should not have a certain criminal record. Some examples particularly relevant to social workers and human services practitioners are the Working with Children, Risk Management and Screening Act of 2000, and also the Disability Services Act of 2006. In Queensland, you are generally only required to disclose convictions until the rehabilitation period has expired. So for convictions of the District and Supreme Courts, this is 10 years. In the Magistrate Court, this is 5 years. Although in some cases the law may require disclosure of criminal convictions irrespective of when they occurred. Depending on the types of offences you were convicted of, this may also affect your ability to obtain employment as a social worker or human services practitioner in particular roles. There is a further relevant consideration. Employers in any field may require a police check. A police check results in a national police certificate, which is different from your criminal record, as it lists disclosable court outcomes and pending charges sourced from the databases of all Australian police services. They may list things like charges, court convictions, penalties and sentences, findings of guilt without conviction, court appearances, good behaviour bonds, or court orders matters awaiting court hearing, warrants and or warnings, traffic offences. Certain convictions such as spent or juvenile convictions may not be disclosable on an NPC in accordance with legislation and policies of the various police services. Similarly, it is possible that a police check may affect your prospects in obtaining particular employment. So, where does all this leave you? I guess if you're going to go and protest, which is your lawful right to do so, do it lawfully. If spoken to by the police or detained by the police, cooperate, give them your name and address, and exercise all your legal rights and obligations. When it comes to working in social work, can I tell you from experience that people who get convictions recorded against them for blue cards or for a certain offence that is disclosable under blue cards, don't panic. There's always submissions that can be formulated, and there's also rights of review through QCAT. So the first important thing is, if charged with an offence, get the right advice immediately. Thank you.
Hi everyone, my name is Deb Kilroy. I'm the CEO of Sisters Inside, and I'm just going to talk to you a bit about protesting. So you're probably wondering, what are your rights to attend a protest? I think it's already been mentioned that Section